This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome. And in case you were wondering how many appellate court judges does it take to open a door, it takes 3 plus the deputy clerk.
On a good day.
They have installed a card reader that has its own attitude about how long the green light will stay open. So it's just another exciting challenge to one's daily life. Good afternoon. On behalf of Judge Stafford and Judge McGee, we welcome you to this docket. I'm Frank Clement. I spend most of my time in Nashville, but I'm part of the Court of Appeals of Tennessee. We are one court, and all of us sit in Jackson, Nashville, Knoxville, and wherever our court may hear cases, because we're one court, and I'm pleased that I have the opportunity to be with you today. We will hear the cases in the order in which they appear on the docket. Each side has 15 minutes to present your argument. The appellant has the option of reserving up to 5 of those minutes for rebuttal. So when the appellant comes to the podium after you've introduced yourself, please tell us how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements? Hearing none, call the first case, please.
Walter Joshlin et al. Versus Hollis H. Halford III, MD et al.
All right, we're ready to hear your argument.
Good afternoon.
Good afternoon.
May it please the court if I could reserve 3 minutes?
Very good.
Thank you, Your Honor. Judge McGee, Judge Stafford, Judge Clement, I'm Amber Shaw, and I, along with Houston Gordon and retired Supreme Court Chief Justice Lyle Reed, represented Walter Joshlin and represent Vivian Joshlin as the plaintiffs in this case. This case has somewhat of a long timeline that I believe is important, and if I may reiterate that brief timeline to you, we filed suit in this case on January 22nd, 2013. Unfortunately, on February 25th, 2014, Mr. Joshlin passed away. The injuries that we sued for are in the nature of personal injury. Specifically, at that time, it was known as medical malpractice. And the underlying cause of action that gave rise to this case was that Mr. Joshlin was catastrophically injured at Health South and had been treated at some point by Dr. Hollis Halford. It is not a wrongful death case. His death resulted from a separate and discrete, unfortunate lung cancer. On March the 25th, 2014, we filed a suggestion of death after reading the Rule of Civil Procedure 25.01, subsection 2. A year later, a little over a year later, on June the 26th, 2015, Dr. Halford filed a motion to dismiss, alleging that we had not complied with Rule 25.01, subsection 1, in that we had not moved to amend to add a different party pursuant to the Rules of Civil Procedure. 3 days later, on June the 29th, 2015, the plaintiffs filed a motion to substitute or amend to try to satisfy the defendants and move the case along. And if the court will recall, this has already been up on interlocutory appeal one time. And we covered a lot of these same issues in that we would have substituted in Ms. Vivian Joshlin, who is the surviving spouse of Mr. Joshlin. On May 20th, 2016, which was over a year later, we were finally able to get a hearing before Judge Russell on the defendant's motion to dismiss. And the court will see that there have been some significant delays because we were not able to get a hearing or get an order entered that would proceed or make the case move along in a faster fashion. We were able to get an order denying the motion to dismiss entered on July the 25th, 2016. A motion for interlocutory appeal was filed on August the 15th of 2016, and the hearing on that motion was heard on December the 8th, 2017. On December the 8th, 2018, the order was entered exactly a year later. And I do want to commend my opposing counsel because we did work both to get hearings set, but we were unable to do that through no fault of our own, and we did have trouble getting the orders entered. Again, all counsel was able to work together to draft the proposed order, but we just could not get it entered except when the judge would sign it. And so after the order granting the interlocutory appeal was filed, there was an interlocutory appeal that the Court of Appeals took up. Judge McGee rendered the opinion, which was on September 18th, 2019. And that interlocutory opinion instructed the case to be remanded to the trial court and for the trial court to make some specific findings on two issues, namely whether or not our response to their motion to dismiss could be construed under Rule 6.03 as a motion for enlargement of time, and two, if it could be construed as a motion for enlargement of time, should it be granted, and then if so, was there excusable neglect present that would give rise for an excuse to why we applied one rule instead of the other. So we went back to the trial court, and Judge Russell recused himself at that time. Some new circumstances had arisen that gave rise to where he did not feel like he could continue to be impartial. And so our case was then transferred to Judge Jerry Stokes in Shelby County Division, I think it's 6. We filed the affidavits of Les Jones and John Day in support of our position that there was excusable neglect that existed. And on September the 3rd, 2020, the affidavits of Les Jones and John Day were stricken by the court, and the court started to interpret this issue as strictly a matter of law. And on September the 17th, 2020, Judge Stokes ruled on the two issues related to the motion of enlargement of time and excusable neglect, which then we asked to appeal since it was now final and the case was dismissed, and now we're here today. I point out this timeline because, in my opinion, it's very important to the progress or lack of progress on the case, and that's one of the elements that we believe, or the relevant circumstances that Judge Stokes should have analyzed. And so we're here today, number one, to reiterate the arguments that we first preserved in our interlocutory appeal. Number one, that the trial court erred when it applied Rule 25.01 instead of 2501.02. I don't want to spend a lot of time on those because we've already argued that before this court once. We did want to properly preserve those arguments for appeal, and so we've done that and we rely on our brief. The two issues that I want to focus on in my oral argument are, number one, that this is a mixed question of fact and law, not a pure question of law, and that the trial court erred when he struck the declarations of John Day and Les Jones. As the court may know, Mr. Day and Mr. Jones are two attorneys in the state of Tennessee, and they both supported our position that it was excusable neglect that had occurred. When the trial court struck those, he found that it was solely a question of law. However, in our opinion, and what we are asking the court to decide, it is a mixed question of fact and law. One has to only look at the actions of the attorney, and those are the facts, and then apply them to the law, and we believe that the affidavits should have been considered. Turning to the meat of my argument, we believe that Judge Stokes respectfully erred because he only analyzed one of the four relevant circumstances that are applicable to the excusable neglect analysis, and we believe that he was required to analyze all four. There is a case that's almost directly on point with respect to this issue, actually two. There's State ex rel Sizemore versus United Physicians Insurance Risk Retention Group, which is 56 Southwest 3rd 557, and it's a Court of Appeals case. And there's Ferguson versus Brown, which is 291 Southwest 3rd 381, a 2008 Court of Appeals case. In Ferguson versus Brown, the court did similarly to what Judge Stokes did here. Judge Stokes analyzed one of the relevant circumstances of the four that exist. The four that exist are the danger or the prejudice to the party opposing the late motion, the length of the delay and the potential impact on the proceedings, the reason why the filing was late, and the filer's good or bad faith. The only relevant circumstance that Judge Stokes analyzed was the reason why the filing was late. And because we have a duty of candor to the court, our position all along has been that we read Rule 25.01 subsection 1 and Rule 25.01 subsection 2, and I did the analysis in our office, and I came to the conclusion that 25.01 subsection 2 applied, and that has been an erroneous finding that has been determined on interlocutory appeal by our Court of Appeals. And the difference in those two is that under subsection 1, we were required to file a motion to amend and substitute a party in within 90 days, or the case shall be dismissed. Under subsection 2, the way that I read the subsection was that we were to file a suggestion of death, and if the party that was remaining in the case, if the cause of action succeeded to them, then there was no need to file a substitution. And that's what we argued initially to Judge Russell at the trial court level, that it was duplicative because they were the same person. In an excusable neglect analysis.
You're referring to the spouse as the person that it succeeds to,
Yes, Your Honor.
but it's not a wrongful death case.
It's not a wrongful death case.
So how does it succeed to the spouse?
Well, what we had argued was that when you look at the relevant statutes and the rule, that the relevant statutes give you the order of priority to which the cause of action succeeds. Not in a wrongful death statute context. It is the wrongful death statute, but you only look to it for the order of priority as to who comes next. And the first person on that list is the surviving spouse. And
But that's under the wrongful death statute.
it's under the wrongful death statute, but you're directed there by one of the other statutes when you're trying to figure out succession.
Okay, which statute is it that you're relying on that you say directs us to follow the wrongful death statute even though it's not a wrongful death claim?
Your Honor, if I may find that.
Okay. Well, I don't mean to delay your argument, but
I understand, Your Honor. We looked at.
if you want to, you can mention it in your rebuttal.
Yes, Your Honor. We looked at 20-5-102. It says the right of action shall pass in a like manner as the right of action described in 20-5-106. 106 is the wrongful death statute. 102 directed us to go there.
102 does what?
Directed us to go there for the order of priority.
And what does 20-5-102 pertain to?
The revival,
Okay.
that the cause of action shall not abate, but it may be revived.
Okay.
And so then it tells you how, like, the order by which, to which it revives.
Now, if we follow your interpretation, would not this render the substitution of parties rules of no consequence?
Well, I think it has to be in very specific circumstances. Here, we had the husband and the wife both as parties already. And my line of thinking when I read 2501 subsection 1 and 2501 subsection 2, it made sense to me that if you've got one person who's been injured and dies, and you don't have anybody else in the case, or you have a child in the case, or someone that would not be the priority person, then you would need to go and move to amend and substitute in.
But in this case, the second plaintiff's claim was a consortium.
It was a loss of consortium derivative claim, but she was still a named party plaintiff.
True.
And so when he died, the way that I read the rule was that I needed to file a suggestion of death, and that she was already there as a placeholder, because that's what we're doing. We're just preserving the fact that we have someone there to be a placeholder. And this was analyzed, and the Court of Appeals, based on the interlocutory appeal by the defendants, ruled that we should have followed Rule 25.01 subsection 1. And so we went back to the trial court, and we had filed a response to the motion to dismiss and asked for an extension of time in our response. And Judge Stokes, we believe, correctly ruled that that could be construed, and there's case law to support that position, that it was a request for an extension of time under Rule 6.03, which would permit us to have longer than the 90 days to then go and get someone substituted in. But then if the trial court found that we had appropriately asked for additional time, then the trial court had also to make a finding about excusable neglect. And he analyzed one of the relevant circumstances, but there are four. And had he analyzed all four, we believe that it would have weighed in favor of an excusable neglect finding when he found that there was no excusable neglect, because he relied on a Western District case that said that misinterpretation of the law is not excusable neglect. And that alone is not. The case law is very clear that if that is the only thing you have, that is not excusable neglect. But that is not the only thing we have under Ferguson. The thing we have under Ferguson are four factors that all have to be weighed, and they have to be, and we've detailed this at page 31 of our brief. In Ferguson versus Brown, the trial court only analyzed one of the four relevant circumstances, just like Judge Stokes did, and ignored the other three. In that case, it was a dispositive motion, a motion for summary judgment, and there was no timely response filed. So it's a motion that's going to end the case, just like this motion to dismiss would have ended our case. The Court of Appeals looked at the facts and the law around each relevant circumstances. So they looked at all four relevant circumstances, and they ended up reversing the trial court because the trial court had only looked at one relevant circumstance. The Court of Appeals looked at all four and found that three of the four factors weighed in favor of excusable neglect.
All right, but if you will save the rest of that for your rebuttal, your
Yes, Your
initial
Honor.
time is up.
Thank you.
Good afternoon.
Good afternoon, Your Honors. My name is Samantha Bennett, and I represent Dr. Halford in this matter. I'm going to be arguing the bulk of the time on behalf of the defendants. I'd like 13 minutes, and I'm going to reserve 2 minutes for Ms. Gullidge, who represents Health South.
All right, 13 minutes, thank you.
May it please the court, as Ms. Shaw mentioned, this is the second appeal of this case, and for the most part, we don't dispute Ms. Shaw's recount of pertinent events, so I won't belabor that. I will say that this court's decision in the first appeal of this case is the law of this case, and under that doctrine, only in very limited circumstances should this court go back and reconsider that decision. Those circumstances that would be relevant are not present here, and under the law of the doctrine, we believe that this court should leave the initial decision undisturbed. In terms of the issues that were remanded back to the trial court, it was the issue of excusable neglect, and it was a twofold question since the plaintiff did not file a Rule 6.02 motion for extension of time. This court asked the trial court to determine whether the plaintiff's response in opposition to the defendant's motion to dismiss should be construed as a motion for extension of time to file a motion to substitute parties, and if so, whether that failure to timely substitute was the result of excusable neglect. These issues are reviewed by this court under an abuse of discretion standard. A trial court only abuses its discretion when it's applied an incorrect legal standard, reaches an illogical or unreasonable decision, or bases its decision on clearly erroneous assessment of the evidence.
Or there's a more modern standard under Lee Medical, is whether there's a factual basis to support the ruling, whether the court identified and properly applied the relevant legal principles, and whether the decision within the range of reasonable alternatives.
Correct, Your Honor.
That's a more practical statement.
Discussion. It is, Your Honor. And as we will show, we believe that Judge Stokes acted within his judicial discretion when he found that the plaintiff's failure to timely substitute parties was not the result of excusable neglect. In answering the first question, Judge Stokes found that the plaintiff's response in opposition to the defendant's motion to dismiss should be construed as a motion for extension of time. We respectfully disagree with Judge Stokes on that point, and do not believe that the plaintiffs should have gotten past that threshold question. We believe that Judge Stokes ruled correctly on the second point, but just for purposes of preservation of the issue on appeal, we believe that Judge Stokes' his decision on the threshold issue was unreasonable for three reasons. One, the trial court failed to consider that the plaintiff's response did not seek any relief that was available under Rule 6.02. The response never requested permission for additional time to file a motion to substitute parties. The plaintiff's response simply argued that their failure was a result of excusable neglect, but it didn't ask for permission to take corrective action. In addition, the plaintiff's response did not even acknowledge that the plaintiffs had missed a deadline and needed to take corrective action in order to comply with Rule 25.011, which this court said was applicable and required a substitution of parties. Even if the response could be construed as a request for an extension of time, the trial court failed to appreciate that the relief sought by the plaintiffs was actually not the appropriate relief. In the response, the plaintiffs state that Ms. Joshlin would have been the appropriate party to substitute in had Rule 25.011 been applied, and that is not correct. There was an estate open, and Vivian Joshlin and her son were the co-executors of the estate of Walter Joshlin. So had a motion for had a motion for extension of time to substitute parties been filed, the co-executors would have been the appropriate party to substitute in. For these reasons, we believe it was unreasonable for Judge Stokes to construe the plaintiff's response to our motion to dismiss as a request for relief when the plaintiffs clearly did not believe that any corrective action was necessary. And for these reasons, we believe that Judge Stokes did not need to move past that threshold question. However, if this court agrees with the trial court that the plaintiff's response to our motion to dismiss should have been construed as a request for additional time, this court should still affirm the decision of the trial court dismissing this case, finding that the trial court did not abuse its discretion when it held that the plaintiff's failure to timely move to substitute parties was not the result of excusable neglect. As mentioned, the only reason offered by the plaintiffs to support their claim of excusable neglect is misinterpretation of the law, that the plaintiffs mistakenly interpreted Rule 25.012 and applied it to the facts of this case, when this court has said that the appropriate rule to apply was Rule 25.011. It is well-settled law in both Tennessee state and federal courts that misinterpretation, misunderstanding, misapplication of the law cannot support a claim of excusable neglect. In our brief, we discuss numerous cases that discuss the concept of excusable neglect in the context of a mistake of law, mostly under either Rule 6.02 or Rule 60. In each of those cases cited by the defendants, the case law makes it clear that when a party asserting a claim of excusable neglect offers only misinterpretation of the law to excuse a failure to timely act, the party's claim of excusable neglect must fail. Significantly, the parties do not refute or challenge the authority of the case law cited by the defendants. Rather, the plaintiffs argue that the trial court erred because it did not apply the four-factor excusable neglect analysis adopted by the Tennessee Supreme Court in Williams versus Baptist Memorial Hospital. Under the facts of this case, the plaintiff's argument is without merit. Appellate courts should start with the presumption that the trial court's decision was correct and review the evidence in the light most favorable to the decision. Discretionary decisions will be upheld where the trial court considered and applied controlling legal principles. In this case, the controlling legal principle is that misinterpretation of the law does not and cannot support a claim of excusable neglect. Because the only explanation offered by the plaintiffs was a mistake of law, misinterpretation of law, the application of this legal principle foreclosed further excusable neglect analysis. The Williams analysis simply wasn't applicable because you did not get to the threshold, you did not get beyond the threshold question of the reason for the failure to timely act. And when it is excusable, when it is a a misinterpretation of the law, you cannot sustain a claim of excusable neglect. Moreover, the plaintiffs have not cited this court to any Tennessee appellate decision that applied the Williams analysis where the sole explanation offered to support a claim of excusable neglect was misinterpretation of the law. The plaintiffs cited you today to Ferguson and Sizemore, and in those cases, the issue supporting the claim of excusable neglect was not misinterpretation of the law. The defendants rely on their briefing, in which we extensively discuss numerous cases, state appellate court cases, federal cases as well, that stand for the proposition that excusable neglect cannot be supported by a reason of misinterpretation of the law. We would point out that the Western District of Tennessee's decision in Wentz versus Best Western International is factually analogous and directly on point. And in that case, the district court said that multiple courts have expressly held that such misapplication or misunderstanding of Rule 25 does not constitute excusable neglect for the purpose of Rule 6b. The case law supports the defendant's position that the full Williams analysis is not required when mistake of law is the only basis for a claim of excusable neglect. However, if this court believes that Judge Stokes should have considered and addressed all four of the Williams factors, this court can and should conduct that analysis on appeal and should reach the same conclusion as the trial court, that the plaintiff's failure to timely move to substitute parties was not the result of excusable neglect. Last week's decision by the middle section in Cunningham versus Frenesius Medical is directly on point. That case involved a failure by a plaintiff to timely move to substitute parties and a claim of excusable neglect. On appeal, the Court of Appeals noted that the trial court did not discuss all of the Williams factors, and then the court proceeded to conduct its own independent review of those four factors. The Court of Appeals essentially found that three of the four factors, the risk of prejudice to the opposing party, the delay in its potential impact on the proceedings, and the good or bad faith of the filer, favored the plaintiff. However, when the Court of Appeals got to the reason for the delay, it noted that that's what the decision came down to. And that's consistent with the Court of Appeals decision in Brandon versus Williams Medical Center, which explained that the reason for the delay is the most important factor in the excusable neglect analysis. The Cunningham court found that the plaintiff's excusable neglect argument was based on a mistaken interpretation of what was required under Rule 25.011 and held that a mistake of law does not qualify as excusable neglect. Although the court in Cunningham went through all of the Williams factors, the court's discussion actually shows that when the reason offered to support a claim of excusable neglect is misinterpretation of the law, the Williams analysis really is not necessary. Because mistake of law can never support a claim of excusable neglect, the other three factors were immaterial to the court's outcome in the decision in Cunningham. In our case, the defendants argued before the trial court that if a Williams analysis was required, which we did not believe it was, and we argued that before the trial court, that the defendants were prejudiced and that there was an impact on the litigation because of the plaintiff's lengthy delay. In this case, the determinative fact is the reason for the delay, and the plaintiff's misinterpretation of Rule 25.012 simply cannot support their claim of excusable neglect. As in Cunningham, if this court finds it necessary to conduct a full Williams analysis, this court should still find that the trial court did not abuse its discretion when it held that misinterpretation of the law cannot support the plaintiff's claim of excusable neglect. And for that reason, the defendants asked this court to affirm the trial court's dismissal of the plaintiff's claim as to all defendants with prejudice.
All right.
And if
Any
there are
questions?
any questions?
Hearing none, thank you very
Thank
much.
you.
We'll now hear from your co-counsel. Good afternoon.
Good afternoon. May it please the court, Aubrey Gullidge on behalf of Health South. Your Honors, I have just a few points to make with our brief remaining time. First, to briefly address the issue of the declarations. The trial court properly exercised its discretion in excluding the declarations of Mr. Les Jones and Mr. John Day. This court has held that to satisfy the burden of demonstrating excusable neglect, a plaintiff has to set forth facts showing why the relief should be granted. The requirement is to set forth facts, not opinions. These declarations are made by declarants who have no firsthand knowledge whatsoever of the facts leading to the alleged failure, the alleged delay in timely filing a motion. Because they lack any firsthand knowledge and they are verbatim based on knowledge, education, and experience, they are immaterial to that excusable neglect analysis. Also, we would reference that the plaintiff has submitted the plaintiff's counsel has submitted their own affidavits asserting basically the same thing, Your Honors. And so here, consideration of those declarations would not only be improper, but they are wholly irrelevant because they set no factual knowledge whatsoever that's relevant. Those attorneys were not involved with this matter. But even if this court holds that exclusion of the declarations was an abuse of discretion, this should not result in a reversal of the trial court's judgment and order. Under Rule of Appellate Procedure 36B, consideration of the declarations would not have, more probably than not, affected the order and judgment. The only fact the trial court considered is whether the plaintiff's mistake of law justified the alleged failure to move to substitute and the alleged excusable neglect. So here, had the court even considered those declarations, it would not have changed the outcome in the order in the dismissal. So for that reason, consideration of the declarations was not warranted.
All right.
Your Honor.
If you'll sum up quickly.
Sure. Thank you, Your Honor. I have nothing further to add to the other points raised by Ms. Bennett. Thank you for your time.
Thank you. We'll hear a rebuttal.
Thank you, Your Honor. To pick up where I left off earlier, if I may,
Sure.
This is absolutely a case of excusable neglect. And had Judge Stokes taken into account the affidavits of Les Jones and John Day and applied all four relevant circumstances, it would have weighed in favor of an excusable neglect determination. And here's why. In State Ex Rel Sizemore, the court has found that all relevant circumstances must be considered, weighed with and against each other, because if considered separately, they may not all point in the same direction in a particular case. One thing I heard opposing counsel mention was that these are factors, but they're not. Sizemore specifically states that all four are to be considered. Whether neglect is excusable is an equitable determination, and it takes into account all of the relevant circumstances surrounding the party's omission, and that's out of Ferguson versus Brown. Had Judge Stokes taken this as a mixed question of fact and law, and had Judge Stokes considered the affidavits of Mr. Jones and Mr. Day, and had he analyzed all four of the relevant circumstances, he would have determined that there was, number one, no danger or prejudice to the party opposing the late motion. That's the first relevant circumstance. The examples that are given in the case law include where one side has been harmed by a loss of an opportunity to present a material aspect of their case, a detrimental change of position by one side in reliance on the action of another, and the filing would burden the non-requested party with additional trial prep or additional expense when there's a limited amount of time remaining for trial. The reason that I outlined the dates and how much time it took us to get through the trial court on these limited issues is because we're still at the very beginning of this case. We have not gone into extensive discovery, extensive depositions, because this came up early on. In Ferguson versus Brown, the court also found that there were specific allegations of prejudice that would be required if the defendants were going to allege that they had somehow been harmed, such as specific arguments demonstrating how they would be prejudiced by being required to do the work. The second relevant circumstance is the length of the delay and the potential impact on the proceedings. Again, the biggest delay in this matter has been the ability to have the motions heard and the orders entered through no fault of the parties. In Ferguson, the court even found that while there were delays due to ongoing procedural issues, it was not relevant to the analysis. The third relevant circumstance is the reason why the filing was late. The filing was late because of our good faith misinterpretation of the law, and that is undisputed. The fourth relevant circumstance is the filer's good or bad faith, and bad faith has never been raised as an issue in this case. So taking all four relevant circumstances, the first one is danger or prejudice to the party opposing the late motion. They've not set forth any. That weighs in favor of excusable neglect. The length of delay and impact on the proceedings, it weighs in favor of excusable neglect. Misapplication of the law, the reason the filing was late, weighs against a finding of excusable neglect, and that's what the case law shows, that that alone cannot be a reason. But the federal court doesn't have the same four relevant circumstance analysis that the state court does, and we have to take into account all four relevant circumstances. And then the final one, there's no question that all this was in good faith, and that weighs in favor of excusable neglect. So respectfully, we would ask that this cause of action be reversed and that Judge Stokes either be required to perform the analysis of all four relevant circumstance factors, or that the Court of Appeals perform its own and find that there was excusable neglect that existed, which would then prevent this case from being dismissed with prejudice.
Thank you to all three of you, and we will take this matter under advisement.
Thank you. Your Honor, that's all I have before you today, if I may be excused.
We can take a vote on that, or you can just leave.
Judge Neal told me one time he wasn't sure if I could be excused or not, so I always like to.
You're excused.